All right, Mr. Vega, why does it take you going to prison for you to wake up and realize that you right what's right from wrong? I don't understand that. Like, why does it take going to prison for you to say, I'm going to get my GED, I'm going to be in my son's life, I'm going to be a good parent, I'm going to get off drugs? Because I'm looking at your history and you've been in trouble.
She called him loving, emotional, caring, open-minded. Those were his wife's words spoken under oath, just minutes before a Texas judge sentenced Fabian Vega to 25 years in prison for murder. The same man she described as a father who deserved to come home had walked into a park, fired a gun into a crowd, killed one person, and shot 3 others. His wife said she forgave him. His 6-year-old son does not know his father's name. The judge looked down from the bench and asked a single question that cut through every sympathetic word spoken on his behalf. Why does it take going to prison for you to realize what is right and what is wrong? He had no answer.
You're 23, and I know what young people think because I was in your position. When people get sentenced to go to prison and they're young, they think it's the end of the world for them. But time goes by so quickly. I can't believe how quickly this year is passing. And you still have a chance to improve your life. Like, there's someone here who's dead. They're not, and I want you to think about this, they're not having graduations. If they were going to graduate, you can say, hey, that person was a horrible person too, or did horrible things. But guess what? They're not going to graduate. They're not going to see any grandchildren maybe they were going to have. They're not going to get a chance to improve themselves here on the planet because...
By the end of this video, you will understand exactly how a defendant's own criminal history becomes the most devastating evidence against him at sentencing, and why a judge's question from the bench can reveal more about the justice system than any legal argument ever could. This sentencing hearing took place in a Texas district court in cause number 2020 CR 6408, State of Texas versus Fabian Vega. Vega entered a plea of no contest to the offense of murder on February 21st. He entered a plea of true to the enhancement, which the court found true based on his plea and the state's exhibits. The plea bargain capped his punishment at 25 years in the institutional division of the Texas Department of Criminal Justice. The court made an affirmative finding of a deadly weapon. The state also took into consideration a second cause number 2020 CR 6409 and a county court cause number. Both parties reviewed the presentence investigation report and had no objections. The state called no witnesses. The defense called one. Fabian Vega was 23 years old at sentencing. He grew up in Child Protective Services custody, removed from both parents, placed in foster care he described as bad, real bad.
No, sir.
Can you please explain that to me?
I grew up on like CPS care, so I was never around my mom or dad, and I was always like, I grew up having like a hard life, so I don't blame no one for my actions that I did. It's just...
He had no relationship with his mother or father. He never graduated high school. He had a drug problem. He had a wife, Brenda Torres, who was 22 years old and working at Whataburger to support their 6-year-old son alone.
I'm 22.
You're 22.
Yes,
And you have a 6-year-old child.
I do.
Have you raised that child alone?
I have.
That's not an easy thing.
She had raised that child by herself while Vega cycled through juvenile detention, state custody, and county jail. Their son, Xavier Vega, was born after Vega was already incarcerated. The boy had never spent meaningful time with his father. He did not know his father's name. His mother planned to tell him when he turned 8. The no-contact order the judge imposed that day would keep Vega from his son until Xavier was 21 years old and capable of making his own decision about whether he wanted to meet the man who had been absent his entire life.
Pass the witness, Your Honor.
Any questions?
Just a couple questions, Your Honor. Ma'am, how old is your son?
6.
6. So he's born in 2017 or
2006.
2016. How much time did the defendant, Fabian Vega, spend with that son back then?
None, because he was in juvenile.
So none. Has he, and he's never seen him?
You've seen him.
Seen him. but he's participated in this son, this 6-year-old, your son's life. How much?
None, because he's been in juvenile and in jail.
He's in juvenile in jail, but he was not in jail when he committed this murder.
The prosecution's case was not presented through live witnesses at this hearing. The plea had already been entered. The guilt was already established. What remained was the determination of punishment within the 25-year cap, and for that, the state relied on the record. Vega had killed one person and shot 3 others. He fired into Father Benavides Park. He shot randomly into a crowd. When asked on cross-examination whether he realized he had shot 3 individuals that day, he answered, "Yes, sir." When asked whether he was aware he had been shooting into a park, he answered, "Yes, sir." When asked whether there were people out there he was randomly shooting at, he answered, "Yes, sir." The prosecution also revealed that Vega's own roommate, a man named Caleb, had been prepared to testify against him. Vega initially claimed a witness backed out. The prosecutor corrected him. Caleb was willing to testify. He was going to tell the truth. Most people watching this hearing missed what just happened. When Vega initially told the presentence investigator he had tried to fight the case with self-defense, then admitted on the stand that self-defense was not what happened, then struggled to explain why he had said it in the first place, saying he was in fear of his life, that he had been shot at before, that it was out of fear, I guess. The word guess doing more damage to his credibility than any prosecutor's question ever could.
Go ahead. Thank you. Mr. Vega, you stated in when you were asked about this incident here, you said that in here it says, "My neighbors told me them where I was, my name, and that I had tattoos. I tried to fight it with self-defense." So are you saying this is self-defense?
No, sir.
Okay, but so that's wrong in here, is that correct?
Yes, sir.
Okay, so did you lie in here?
No,
Excuse me?
no, sir.
But it says self-defense here.
I was in fear of my life at that moment. I've been shot at, but he seemed proud in the past, so it was out of fear, I guess.
Here is the legal annotation. At a sentencing hearing in Texas following a plea of no contest, the rules of evidence are relaxed. The court may consider any matter the court deems relevant to sentencing, including the circumstances of the offense, the defendant's criminal history, and the defendant's character. The presentence investigation report, or PSI, is prepared by a community supervision officer and contains the defendant's full criminal history, family background, educational history, employment record, and any victim impact statements. The PSI is the single most important document at sentencing because it is the document the judge reads before the hearing begins. It shapes the judge's understanding of who the defendant is before any witness takes the stand. When Vega told the PSI investigator he acted in self-defense and then disavowed that claim under oath, he created a credibility problem that no character witness could fix. The legal standard at sentencing is not reasonable doubt. It is a preponderance of the evidence, and sometimes it is simply the judge's assessment of whether the defendant understands what he did. The question the cross-examination was about to answer was not whether Vega committed the crime. He had already admitted that, but whether he was still minimizing it. The cross-examination was not long, but it was surgical. The prosecutor asked Vega directly, "Did you feel that you had a right to kill that day?" "No, sir." He then asked whether Vega realized he had not just killed one individual, but shot 3. "Yes, sir." He asked whether Vega was aware he was shooting into a park. "Yes, sir." He asked whether there were people out there he was randomly shooting at. "Yes, sir." Then the prosecutor turned to the witness Vega had claimed backed out. "Your roommate Caleb was willing to testify against you. You do realize that?" "Yes, sir." "So how did he back out?" "Because he was going to tell the truth, I don't know." The peak revelation arrived in 4 words. I don't know. The man who had told his wife he was loving, who had told the court he wanted to be a good father, who had promised to get his GED and break his addiction, could not explain why the one person who lived with him was prepared to testify for the prosecution. Here is what that actually means in the real world. When a defendant's own roommate is willing to testify against him, the jury or the judge no longer has to choose between the word of law enforcement and the word of the accused. The credibility contest is over. The defendant's own witness, the person who shared his home, has become evidence for the state. That is not a procedural loss. That is a complete collapse of the defense's moral position, and it happens silently in a single answer while the courtroom takes notes.
Like different, it was out of fear, I guess, like my reaction.
You know, you didn't just, you killed one individual, but then you shot 3 individuals that day. You do realize that, correct?
Yes, sir.
And that you were shooting into a park, Father Benavides Park. You're aware of that.
Yes, sir.
And there are people out there that you were randomly shooting at. You're aware of that.
Yes, sir.
And then you say a witness of yours backed out. Who was the witness?
My roommate Caleb.
Caleb.
What should have happened differently begins years before this hearing. A child placed in CPS custody should have received mental health treatment and educational support sufficient to interrupt the trajectory that began with graffiti at a church in 2013 and escalated through possession, evading, and juvenile detention in 2014, 2015, 2016, and 2017. The Texas Juvenile Justice Department, formerly the Texas Youth Commission, had custody of Vega at some point during those years. That agency is legally obligated under Texas Human Resources Code Section 245 to provide rehabilitation and treatment. The record does not show that rehabilitation occurred. What the record does show is that Vega cycled through the system, picked up new charges, and emerged at 23 facing a murder sentence with a 6th grade education, a drug addiction, and no adult criminal record because he had barely been out of custody long enough to acquire one. The prosecutor should have been required to confront the fact that the state of Texas had years to intervene in this defendant's life before he picked up a gun and walked into a park and failed. The defense attorney should have called a mitigation specialist to explain what years of institutionalization do to impulse control and decision-making capacity. A properly prepared witness, Brenda Torres, would have been able to describe not just that Vega was loving, but specifically what treatment he needed and why he had never received it. The cost of these failures is measured in the life of the person Vega killed, the 3 people he shot, the 6-year-old boy who will grow up visiting his father in prison, and the 25 years the state will spend incarcerating a man it had every opportunity to help before he became a defendant. The accountability mechanism for the agencies that failed Fabian Vega as a child does not exist because the state does not sue itself for failing to rehabilitate the children it takes into custody, and the people who make those institutional decisions never sit at the defendant's table. Here is the second legal annotation. The defense's strategy at sentencing was to present Vega as a man capable of change. His wife testified he was loving and caring. He testified he wanted to get his GED, complete drug treatment, take parenting classes, and become a good father. This is a standard mitigation strategy under Texas Code of Criminal Procedure Article 3707, which permits the defense to present evidence of the defendant's character and circumstances that might persuade the court to impose a sentence below the maximum. But mitigation evidence only works if it creates a coherent narrative of change. The judge had Vega's entire juvenile record in front of her. She had read the PSI. She could see that Vega had been given opportunities for education and treatment in state custody and had not taken them.
Yes, sir.
Why would you need to learn how to be a loving father?
I was never taught how to be one. I never had that growing up, so I would like to learn. So when I go home, I could be one. That's my time.
What about the drugs?
With the jokes as well. I plan on going down there and taking drug tests to it as well. I had a bad drug problem growing up, and I would like to fix that before I do go home.
Most people believe that a defendant who expresses remorse and promises reform has made a compelling case for leniency. That is not how sentencing works when the defendant has a decade of documented failure to reform. The question is not whether the defendant sounds sincere at the hearing. The question is whether anything in his history suggests he will follow through. When the judge asked Vega why it takes going to prison for him to wake up, she was not asking for his explanation. She was identifying the contradiction at the center of his entire mitigation case, and she was doing it in a single sentence. The prosecution's closing argument was simple. The state asked for the maximum 25 years. The defense asked for mercy. The defense attorney acknowledged what could not be changed: the fact of a death, Vega's childhood without parents, his poor choices, his absence from his son's life. But the defense argued this was Vega's last chance to turn his life around. He had explained his plans, his goals. He did not want to spend the rest of his life in prison. The defense asked for leniency in full knowledge that nothing could change the fact that the court was dealing with a murder.
Years. State, I'm assuming you're asking for 25?
Yes, Your Honor.
All right. And defense?
Our defense is asking for mercy, and we're asking for that in a situation where there's been a death, a murder, and that life can't be brought back. So there's nothing we can say to change that fact. This young man, having growing up without a father and mother, there's nothing we can do to change that either. This young man making poor choices, not being around his son as his son was growing up, and being rather with people who are involved in drugs and guns. There's nothing we can say to change that either. But we have heard from him. He knows that this is pretty much his last chance to turn his life around. He doesn't want to spend the rest of his life in prison. So we are asking for mercy, Your Honor. He has explained what his plans and goals are to the court, being get his high school diploma so he can get a decent job out there, and take enough education and courses and therapy so that he's able to break his chains of addiction, Your Honor, and also learn to be a good parent to his son who's out there waiting for him.
The judge then spoke directly to Vega. She told him that at some point, actions are our own. We can no longer blame a rough childhood. Many people had rough childhoods. Many people had parents who were not in their lives. Some had parents who were in their lives and should not have been. She told him she looks at people as individuals.
All right. And Mr. Vega, I want you to know at some point in time, our actions are our own. We can no longer blame it on the rough childhood we had, because a lot of people had a rough childhood. A lot of people had parents that were not in their lives. Some people had parents who were in their lives and shouldn't have been in their lives. But I do take in consideration when I hear that, because as a defense attorney, I used to always get upset when the state would say, well, this person didn't commit a murder and they had a rough life. I want you to know I look at people as individuals. You understand? All right. So I'm going to sentence you to 25 years in the prison.
Then she imposed the sentence, 25 years in prison, an affirmative finding of a deadly weapon, a recommendation, not an order, for the therapeutic community program to address his drug addiction, a no-contact order with his own son until the boy turns 21 and can decide for himself whether to open that door.
I'm going to do a no-contact order with Xavier Vega until the expiration of $15 years. At that time, he'll be 21. All right. Okay.
This is from Jessica Hernandez. On that day, when you took my nephew's life, you ruined my family forever. You not only took my nephew, but my sister, his mother as well. This has fully impacted my life and the life of my family forever. Your actions that day were purely selfish, and because you decided in your selfishness to pick up a gun and shoot 3 unarmed kids. I am not only without my nephew, but my sister has not been able to cope with what you did, and she suffers from mental illness and is not the sister I once had. It has taken me 3 years to forgive you, and forgive you I have because I have realized that I am not your judge. Only God can do that, and you will face him one day. That is on you. But for you to be released back into society is something I pray will never happen. The thought of you being free to do this again chills my soul. Words cannot express the emptiness in my heart since my son was taken from me. We ask for justice and the punishment you deserve for this crime. It's ironic that the day after Jesus resurrected is what counts, because his judgment is final. I am at loss for words to truly express what you have taken from me. Jesse was not only my son, a part of me, but Jesse was my life. You tore a huge part out of my heart. I died that day too. You may not have cared for your actions that day, but those actions will have a consequence today. I hope you just melt in misery for the rest of your life and that it haunts you till no end, because I've lived like this since that day. I have no pity for you or what.
This ruling upholds the principle that sentencing is an individualized inquiry into the defendant's character, history, and prospects for rehabilitation, but that the inquiry is bounded by the facts of the offense and the defendant's own record of failure to change when given the chance. This is the same sentencing philosophy that the Supreme Court articulated in Williams v. New York, the 1949 case that established a judge's right to consider information beyond the strict rules of evidence when determining punishment, a principle that cuts both ways, allowing mitigation evidence and criminal history to sit side by side in the same judicial mind, weighed on the same scale, with no guarantee which side will tip. Here is what this case means. The criminal justice system does not start at the moment of arrest. It starts years earlier in foster homes and juvenile facilities, in missed appointments and uncompleted treatment plans, in the long, slow failure of institutions that exist to intervene before a child becomes a defendant. When those institutions fail, the system does not apologize, it sentences. Fabian Vega did a terrible thing, and he will pay for it with a quarter-century of his life. But the state of Texas will never have to account for the years it had him in its custody and gave him nothing that made him better. That silence is not in the trial transcript, it is in the space between every line. Was Fabian Vega's 25-year sentence the just punishment for a man who took a life and injured 3 others, or was it the inevitable endpoint of a system that took custody of a child, failed to rehabilitate him, and then punished him as if he had arrived at that courtroom entirely on his own? And if the second explanation is even partly true, what does that say about the difference between justice and consequence?